Good morning and welcome to the Montana Law Review's Judge James R. Browning Symposium on the Future of Federalism. My name is Martin Burke. Prior to retiring from the University of Montana School of Law, I had the distinct privilege of serving for many years as the faculty advisor for the Montana Law Review. Before I introduce the Honorable Bryan Morris, who's going to serve as the moderator of this morning's panel, I want to say a few words about the Montana Law Review and about Judge Browning. 25 years ago, in the fall of 1989, in this very ballroom, the Montana Law Review held its first symposium. The topic of that symposium was the Montana Constitution, the 1972 Constitution. That Constitution required that every 20 years there be a ballot issue placed before the Montana voters. Should we call another constitutional convention? At the time, in 1989, when we were nearing an election where that issue was going to be on the ballot, there was really no discussion in this state about our Constitution and about that ballot issue. The editors and the staff of the Montana Law Review determined that the review could play a very important role in generating a dialogue in this state about the Constitution and about that ballot issue, and indeed they did. We had hundreds of people here and the press from around the state present. I think the review really did a great service to the state of Montana in terms of that very first symposium. Well, since that symposium a quarter of a century ago, the review has continued to sponsor symposia addressing issues really of great importance, not only to Montana, but to this entire nation. Thus, for example, the review in its past symposia has addressed topics such as the right of privacy, and of course, beyond Montana's constitutional right of privacy, that broader right of privacy that is much discussed at the federal level. The Second Amendment, tribal sovereignty, and religious freedom, to name just a few topics. This year's symposium, consistent with that tradition, brings together outstanding jurists and scholars to address another front-burner issue, the future of federalism. Last evening, we heard an excellent and provocative lecture by Professor Ilya Somin of the George Mason Law School. And I know this is being recorded, and so if you weren't present last evening, you want to hear that lecture. It's truly a provocative lecture and a great start for this symposium. And today, you're going to be treated to a series of intellectually stimulating panel discussions with the concluding address this afternoon by Professor Roderick Hills of the NYU School of Law. And now to Judge Browning. As I indicated, Judge Browning is honored by our Law Review through the dedication of this symposium series. As Professor Hillary Wandler noted last evening, Judge Browning, who grew up in Belt, Montana, that big metropolis to the east of us here, was one of 8 law students who in 1940 created the Montana Law Review. He served as the second editor-in-chief of the Law Review. His brother Bill was the first editor-in-chief. So those boys from Belt, Montana really were the leaders of the Law Review in its origin. Professor Wandler outlined Judge Browning's remarkable history of service to this nation. How many of you, just a show of hands, have ever been in San Francisco to the building that houses the U.S. Court of Appeals for the Ninth Circuit? Okay. For those of you who haven't, this is a truly magnificent building. And what you're going to see on that building is the name James R. Browning, the kid from Belt, Montana. You have to love it. Montana's favorite son. And how appropriate that that building was named for him. Now, although Judge Browning spent his entire professional life away from Montana, he never forgot his roots. He loved our law school and he loved our students. He and his wife, Marie Rose, and by the way, the two of them met here on the University of Montana campus many years ago. He and Marie Rose made it a point to visit our law school whenever they could. The judge served in the 1990s as a jurist in residence at our law school, and he had such fun, and so did we. He attended our classes, he taught classes, he gave lectures, and he worked with our students. It was a wonderful experience for everyone. Well, given the judge's relationship to our law school and to our law review, it truly is fitting that the Montana Law Review would dedicate not only its symposium series, but its annual Browning Lecture to James R. Browning. And now it's my honor to introduce the moderator of this morning's panel, the Honorable Bryan Morris. Judge Morris grew up in what we like to refer to as Butte, America. He graduated from my old high school, Butte Central High School, where he was not only a star athlete, but truly a star student. He earned his undergraduate, his master's, and his law degrees from Stanford University, and again, he was an outstanding athlete and an outstanding student there. He was law clerk to the Honorable John T. Noonan on the Ninth Circuit, and the Honorable William H. Rehnquist of the United States Supreme Court. He served as solicitor for the Montana Department of Justice, and from 2005 to 2013 served as a justice on Montana's Supreme Court. He was nominated to the federal bench by President Obama and sworn in as federal district judge in December of 2013. Please join me in welcoming one of our great native sons, Judge Bryan Morris.
Thank you, Martin, and thank you to the Law Review staff for including me on this panel, especially Colin Phelps. I was intrigued to see the topic of the panel called Cooperative and Uncooperative Federalism at Tribal, State, and Local Levels. It jumped out at me that we in Montana live at the vortex of these various levels. We have about 1/3 of our state is comprised of federally owned land. That includes land, but that's United States Forest Service land, Bureau of Land Management lands, land designated wilderness areas, as well as Glacier National Park, Yellowstone National Park, and 7 Indian reservations. I'm trying to have all these entities, the federal government manages the federal lands, the tribal governments, state governments, and local governments all work in concert is no easy feat, and that's where we get the cooperative and uncooperative federalism notion. And as I was thinking about this topic, I was reminded of an Ivan Doig novel that I read called Dancing at the Rascal Fair. And in that story, Mr. Doig talks about 2 young friends from Scotland who immigrate to the United States in about 1889, right around the time of statehood. And they end up settling along the northern Rocky Mountain front and soon get into sheep farming. And everything's going quite well for the young immigrants along with some of their fellow immigrants in the area, and they're becoming somewhat prosperous in the sheep industry and all the problems they fight. Well, around 1907, a new character emerges on the scene, and he's a U.S. forest ranger. And he explains to the sheep ranchers that President Roosevelt and Congress have just designated much of this public domain, this grazing land, that they, free grazing land they used, to be a U.S. national forest. And at the same time, the settlers or the immigrants were slowly being deprived of their right to borrow grass from the Indian reservation, as they described it. So suddenly they're faced with the prospect of limitations on their use of what had been public domain land as well as access to the Blackfeet Indian reservation. And this is 1907, and the forest ranger character was portrayed as quite a reasonable man, and he managed to talk sense to the locals, persuaded them to go along with the notion of grazing allotments on national forest land, and with the reason being that when everyone compromised a little bit, all of the group benefits as a whole. And the kicker for it was, as long as the forest ranger put a limit on the bad character cattle rancher in the area. And the forest ranger's resolution was, well, each of the sheep farmers that had been using that forest land got to keep 1,000 sheep up there. And the idea was 1 cow per 5 sheep. So it took about the same amount of land to feed one cow as 5 sheep. So he insisted to the local sheep ranchers that he limit the bad character cattle rancher to 200 head of cattle on his allotment. And everyone went along. And things went along fine, and suddenly we have the system we have today. So fast forwarding 100 years, I was wondering what would happen in 2007 if the same forest ranger showed up in the same area along the Rocky Mountain front in Montana and proposed cutting the grazing use of the local ranchers. I'm not sure it'd be quite as harmonious as Ivan Doig portrayed it, but we'll get some idea of the issues raised during this symposium today. Now, my panel has some distinguished folks, and the first one I'm going to introduce is Professor Sarah Krakoff, who's from the University of Colorado School of Law. Professor Krakoff graduated from Yale University in 1986, attended Bolt Hall, got her law degree there at the University of California, Berkeley, and went on to clerk for Judge Warren Ferguson of the U.S. Court of Appeals for the Ninth Circuit. She later was awarded an Equal Justice Work Fellowship to work for the Navajo Nation as director of the Youth Law Project for DNA, People's Legal Services. And then she went on to teach at the University of Colorado, and her recent article examines the effect of federal law on the Navajo Nation's exercise of sovereignty that received the Writing Award from the University of Colorado in 2006. And she's written extensively on the topic of tribal sovereignty, including the virtues and vices of sovereignty, the renaissance of tribal sovereignty, the negative doctrinal feedback loop, and the rise of new exceptionalism, and a narrative of sovereignty, illuminating the paradox of domestic dependent nation. So Professor Krakoff has some provocative ideas about this, and she'll pick up on some ideas that Professor Matthew Fletcher, who couldn't be here, talks about. And as Professor Fletcher notes, you look at the U.S. Constitution, it talks about Congress being in charge of regulating commerce with the tribal governments. And think about what the idea was in 1787. What would tribal governments look like? Would there be such a thing? I'm not sure the idea of reservations and land holdings by tribal governments and existence of tribal governments was even contemplated. But nevertheless, the Constitution has at least that mention of it. But only that. And so now, of course, we know today of the concept of tribes as domestic dependent nations, and they're regulated by Congress and the executive branch. Courts have started to push back a bit and say, well, Congress is overreaching. And not surprisingly, Justice Thomas, in a recent case, talked about very explicitly that the Constitution limits Congress's regulation of Indian tribes to commerce. And this is a case involving the Indian Child Welfare Act that say they have no business regulating individual Indians, let alone where those Indian children may live. So that's something we're going to have to deal with in the future is how do we strike this balance between the notion of sovereignty of tribal governments, meaning managing their own resources, managing their own lands, in the context of the federal government that has control over them, mainly the purse strings, and how do they interact with their neighbors? And they're not clear boundaries, oftentimes, clear natural boundaries between the reservations in the state of Montana in which they live. So I'm going to introduce Sarah Krakoff to get the conversation started.
Well, thank you for that generous introduction, and also to all the members of the Law Review who have organized this and been so kind and polite and generous with their time in shepherding us around and nagging us by email and so forth to get our forms in. And anyway, it's a wonderful conference, and I'm very happy to be a part of it. You can probably hear I've had a cold for the last week, and I'm going to try to stay within my 10 minutes anyway, but if my voice gives out before then, then that will be my own timekeeper, and I apologize for that. As Judge Morris said, I'm going to talk about federalism and, to some extent, constitutional interpretation issues. I'm not a common law expert, though, so that's my huge caveat, in the context of tribal sovereignty and federalism through the prism of this recent Indian Child Welfare Act case that was decided last year by the Supreme Court, Adoptive Couple versus Baby Girl. So I have a couple different versions of the title for this talk / paper. One of them is, just so this will give you a sense of where it's going, Against Indian Law Originalism. That's a possible title. Another one is Congressional Power and the Third Sovereign, so that leaves things a little more open. So here's the overview. So this is what I'm going to tell you, and then you can either space out for the remaining 8 minutes, or if I don't quite get to it, at least you know where I was hoping to go. So my big idea is that the Indian Child Welfare Act, which was a federal statute passed in 1978, that readjusts the boundaries of jurisdictional authority over child welfare cases involving Indian children and Indian tribes, and it readjusts them between the states and tribes. That the Indian Child Welfare Act promotes federalism values, if by what we mean by that, in part, is fostering local control and allowing the local level of government to manage its own affairs, right? ICWA does promote underlying federalism values if we consider that the third sovereign should be a part of our federalism conversation. And originalism in its sort of hard form, which I think a lot of the commentators and scholars of originalism would suggest is really its only form, right? So not just that the original meaning of the Constitution derived either by the drafters or makers' intent, right, subjective intent, or original public meaning, should govern, should trump other interpretive modes, right, for figuring out what the Constitution means and does. Originalism in the context of the Indian Child Welfare Act and federalism, if we include the third sovereign, undermines federalism values. Okay, so that's the big idea. So here we'll walk us through it. So the Indian Child Welfare Act, as I mentioned, was passed in 1978, and it was passed by Congress with overwhelming bipartisan support, remember that, when we used to have that, to address a devastating problem with respect to the removal of Indian children from Indian families and homes. And the rates of removal were wildly disproportionate. The Indian children were removed from their homes at rates, between like 2 and 10 times the rates of non-Indian children of any other race. And a significant part of the problem was at the low end, we'll call it sort of benevolent ignorance, and at the high end, just outright discrimination by a range of people involved in child dependency, neglect, and abuse work, including state social workers. So the statute was passed to redress this, and it includes, and this is in broad brush terms, 2 big aspects. One is procedural. It requires state courts to abide by the Indian Child Welfare Act's heightened procedural protections for placement and removal of Indian children, and it also has a substantive component. It not only has these heightened procedural protections, but has different substantive law that applies in the context of removal, foster care placement, and adoption proceedings involving Indian children. So this is a big federalism moment in our field, the field of American Indian law, and I would suggest for all of us generally all over the country, a federal statute that tells state courts what to do in family law cases. This was a hard pill for a lot of state courts to swallow, but more than 3 decades later, and I'll come back to this, the Indian Child Welfare Act is working actually extremely well. We hear about the hard and difficult cases, and there are several of them every year. But in a lot of cases that we never hear about, the Act kicks in to require state courts to cooperate with tribes and tribal courts and tribal governments and state social service workers and state attorneys and adoptive parents and everyone who works in the family law realm to figure out how to achieve the best possible placement, including these values of the preservation of tribes and tribal culture, right? That's part of what constitutes what's best for Indian children in this context, right? The Act works to bring all those people together to achieve those outcomes, and in general works really well, and there are several studies that have shown that this is the case. So that's the Indian Child Welfare Act. So last year, in Adoptive Couple versus Baby Girl, there was a case that got a lot of publicity and attention, and maybe I'll just ask how many of you in the room had heard of this case? It was sometimes called the case involving baby Veronica. Okay, so I don't know, roughly a little more than half, and that's pretty good for Indian law cases that get to the Supreme Court. Most of them, you would never have heard of if I recited a quick version of the facts. So it got a lot of publicity and attention because, like a lot of family law cases, it was a terrible and sad story in many respects. And by the time it got up to the Supreme Court, there was just no chance that everyone was going to come out a winner. So in brief, the case involved the adoption of a child whose mother was not a tribal member, She was not married to the father, who was and remains a member of the Cherokee Nation of Oklahoma. They were not married, and they had talked about getting married. She got pregnant. They were not getting along. He was in the military and was about to be sent to Iraq for a tour of duty. They had some rather strained conversations about the future of the child, and this became like a key fact that was repeated in the Supreme Court opinion. Now I've seen in the lower court opinions following the adoptive couple versus baby girl case as well, that in a text message exchange in which she said, do you want to pay child support or relinquish your parental rights? He said, I'll relinquish my rights. And I mention that because I think that became iconic, like as a sign of what a callous, like jerky father. Essentially, he should have no rights in this case at all. There's a whole other factual story that has become buried because it was not the factual story adopted by the majority of the Supreme Court in an opinion by Justice Alito. And the story from the father's side, and these were all facts that were found in the Supreme Court case, affirmed in the Supreme Court case of South Carolina, that affirmed the lower court, the state courts of South Carolina's findings in the case. And it was essentially a story that went something like this couple were not having an easy time. He said, fine, you can raise the kid on your own. He thought that she was going to raise the child by herself, not that she was going to place the child up for adoption. As soon as he found out that that was the plan, he tried to revoke, literally pull the papers back from the process server who got him to sign papers he didn't know what he was signing. And it started as soon as he learned that the child had been placed for adoption to object to her adoptive placement. Okay, so that's a little backstory, and there are a lot more factual details to tell about the adoption of baby Veronica. But for our purposes, I'll try to cut to the chase a little bit. So she was adopted by this non-Indian couple, and the father objected, invoking the Indian Child Welfare Act and its priority for placement of children with an Indian family in the Indian tribe and so forth. So the South Carolina state courts affirmed that ICWA controlled, and the child, when she was 2 years old and had been with the non-Indian adoptive parents for 2 years, was then transferred to the father. So there's this very moving and tearful scene, right, where this child who's never met her father is taken from the adoptive parents' home and returned to the father. Well, 2 years later, there's a reverse of this scene after the Supreme Court has gotten the case, and what they decide is that the Indian Child Welfare Act does not apply. There were constitutional issues raised by the adoptive parents and the guardian ad litem. They were not addressed except in a avoidance kind of way by the Supreme Court, and instead the Supreme Court decided the Indian Child Welfare Act did not apply to this case because for statutory interpretation reasons, that the father had never had custody of the child, so a provision that requires that consideration of continued custody has to follow the provisions of the Act was ruled out, and then another provision that says the ICWA's provisions apply to any situation in which there's a breakup of the Indian family did not apply because there was no Indian family to break up because the biological father had never had custody of the child. So the case was decided on statutory interpretation grounds. Just to give you a sense of whether this was a really good textual approach to the statute, Justice Scalia dissented. And Justice, which is really interesting, and he typically does not dissent in Indian law cases in which the decision goes against the tribe. And I think the general sense is that what pulled at Justice Scalia's heartstrings, and Justice Scalia does have heartstrings, was the father's rights aspect of the case. That's sort of, I think, the inside baseball understanding of it. But in any case, also we have to accept that probably this was not really the best textual reading of the statute. And I won't go into it in detail, but if you're interested, go look at Justice Sotomayor's dissent from the case, where she really digs in on the sort of nonsensical statutory interpretation moves that the majority makes. So why did they make this move? Well, this was a case that pulled at people's heartstrings, right? And I think underlying it was a sense that if you weren't familiar with the Indian Child Welfare Act, and also if the father's narrative of the story had been successfully buried by the parties by the time it got to the Supreme Court, It cuts against your sense that, well, state law and state courts ought to govern these kinds of proceedings, right? And that if we tiptoe, any further in the direction of the Indian Child Welfare Act controlling these kinds of cases, then we're going to tread into, in the majority's version of the concerns, equal protection concerns. So I'm not going to talk about the equal protection issues, and I know I'm almost out of time, so I'm actually hardly going to talk about anything else. But nonetheless, I want to talk about the other set of constitutional concerns not raised by the parties, not addressed by the majority opinion, but as Judge Morris mentioned, addressed in quite a serious amount of detail by Justice Thomas in his concurrence in the case. He joined the majority's statutory interpretation outcome for the case, which is what does not apply to this proceeding, for constitutional doubt reasons, not concerns about the Equal Protection Clause, but concerns about the source of congressional power to pass the Indian Child Welfare Act. And here the case comes home because Justice Thomas relied very heavily on an article by a former Montana law professor, former Professor Nadelson. He published an article in the Denver Law Review in which he argues that the originalist case for congressional plenary power over Indian affairs does not exist, right? So he does a sort of hard version of originalist methodological interpretation with respect to the Indian Commerce Clause and concludes that neither the drafter's subjective intent nor the original public meaning of the Indian Commerce Clause authorizes Congress to pass legislation that goes beyond a very narrow definition of commerce, one, and two, that would intrude into traditional state powers, i.e. family law. So Justice Thomas's constitutional take on the Indian Child Welfare Act would be that it's unconstitutional because it exceeds one of Congress's delegated powers. In my remaining 30 seconds, I'll just suggest that in addition to all the reasons that many commentators of the years have criticized as sort of a hard version of originalism in general as an approach to constitutional interpretation, and those include, or the criticisms include, roughly that, first of all, internally, the methodology is never as watertight as its proponents would like to suggest. And I will say that having read Professor Nadelson's article, there are a lot of gaps and leaps in logic that he makes. And it's not to say that there isn't a case for a limited version of the Commerce Clause in Indian affairs, but I don't think that he makes it terribly convincingly. And yet now, this has been adopted by the Supreme Court. I think if you take the time to engage in originalist methodology, it has a lot of power and sway. It's like doing a complicated mathematical proof. The other side has to do a ton of work to undermine it. And so voila, it sort of becomes the answer. So that's one kind of critique of originalism, and there are several others. And then there's sort of the living Constitution comeback, which is our Constitution wasn't ever meant to be interpreted solely according to its sort of locked-in-time understanding at the time of the founding. Originalism, right, the framers wanted us to have a living document. That's one version of it. And then another version of it is what the framers really wanted was to create a government. And they did that. So good for the framers, and now we get to figure out in our times today what that government means. So I'm just giving you the incredibly crass thumbnail version of responses to originalism generally. I would add just one more for you to think about, and in the article version I'll delve into this more. In particular with respect to groups who are left out of the document. So more typically we talk about this in the context of African Americans, right, slaves, and also women, other groups just not included. There's a sense in which if we got to the original meaning, we really wouldn't actually like the effects. It would just cut out these groups entirely. And there's a very interesting article that came out pretty recently called Our Savage Constitution by a young scholar, I think he's going on the job market now, who he himself is not an originalist, he's a legal historian. And his legal historian's take on the founding moment, the move from the Articles of Confederation to the Constitution, was that it was very much informed by, in a way that we don't talk that much about, the need and desire, and this was sold in strong terms to the southern states, and particularly Georgia, who were on the fence about whether to ratify, that we needed to make the move from the Articles to the Constitution, in particular because we needed a strong and powerful and unified federal government with a unified fisc and a strong military, so that we could defeat the Indian tribes, both within states and on our borders. And Georgia in particular was engaged in a fierce battle with the Creek Nation at this time. And he makes the case, Orlovsky, who wrote this piece, that this is what tipped the scales for Georgia, was this overarching argument that consolidated exclusive federal power over tribes will help you defeat the Creek Nation, so you should ratify. So, if we pull the lens back a little bit on an originalist take, that it gives sort of both, you could say, the left and the right a little of what they want, right? On one hand, the case for congressional power to legislate with respect to tribes can be justified from the founding's move from the Articles to the Constitution. On the other hand, the ultimate objective that I think was understood as a matter of public meaning at the time was that tribes would disappear, right? So I think no matter which way you try to bring in some version of originalism and apply it in sort of a hard form, it doesn't really tell us anything particularly useful about how we should think about Congress's relationship with tribes and then also with states today. So now I'll try to circle back a little bit and wrap up, since I know I have exceeded my time. So where does this leave us in terms of thinking about the Indian Child Welfare Act and the federalism values represented in that statute with respect to tribes and states today? Well, I took a very quick look at post-adoptive couple versus baby girl cases, and it's very interesting. I mean, it reassured me that states, tribes, all the parties involved, really for the most part, are doing pretty well under the Indian Child Welfare Act. They have figured out how to make this statute work. There are aspects of the act, in fact, that have been adopted within state law but with respect to Indian Child Welfare Act cases and also other cases, because the statute has a sort of more holistic approach to trying to keep families together. And some research has indicated this is what's good for all kids, not just Indian kids. So the ICWA has had that positive effect. It has had a positive effect of bringing, again, all these governments and parties together to try to figure out what's going to work best for kids. There are still hard cases, as there are always going to be in family law. But to the extent that the Supreme Court has weighed in with adoptive couple versus baby girl, even though, in my view, fortunately, it didn't go the way of Justice Thomas's concurrence and just strike down the statute. Nonetheless, its interference, because its strained interpretation of the statutory terms, has not helped states, tribes, and the other parties to figure out how to work together under ICWA. In fact, it's thrown the occasional wrench in to some of the cases, like set some of the state courts back who are just getting used to ICWA and are like, oh, well, now we can sort of find these cute statutory ways to avoid applying it. Not your Supreme Court, by the way. I still think they're doing a remarkable job, including in the most recent case, in which they do apply adoptive couple, but I think in an entirely reasonable way. To conclude, finally, I think that following originalist methodology to what some at least would report to be its logical end in the context of Indian law would actually undermine larger federalism values that we all care about, whether we know intimately about the third sovereign and federal Indian law or not. Thanks.
Thank you, Professor Krakoff. So we're going to let all the panelists speak, and we'll have some dialogue among the panelists and then questions from the audience. Professor Krakoff's comments, though, brought to mind something that we talk about a lot in the law. There's a sense that if the Supreme Court would just decide something, we can all move on from this debate and get it over with. And that's done. We've already dealt with that. There's a real impatience often among particularly law students and even lawyers, people in the public. They want the Supreme Court to decide it and move on. We don't have to address that issue anymore. And as Roe versus Wade, I think, points out very well, it doesn't necessarily resolve anything. It just keeps pushing the issue back. And when I was a law clerk for Chief Justice Rehnquist, one of the roles of the clerks was to review the thousands of petitions for cert that were filed annually with the court. And we write a memo that was circulated among the pool of the rest of the justices, and we review the ones we had written and then review the other clerks' memos. And on the top, you would notate the other clerks' memos for your boss, decide what you thought of the cert petition, whether it was worthy of the court's consideration. And one of the shorthand notations that was often put on there was, well, interesting issue, but further percolation recommended. And what that meant was, well, let's wait. Let's put this off. Let's let other people think about this. Let's let the issue evolve for a while and see where it goes. And because the final resolution means you may not like the outcome. You may not like what the Supreme Court does. And let the circuit courts and the district courts bat this around for a while and let intelligent people think about the issue and the ramifications of an outcome and how it may affect the future. And then when we do finally get the Supreme Court, we're not often satisfied with the outcome. Not because our side won or lost, but because the court avoided these constitutional issues. They had a pragmatic outcome. They said, well, they latch on to an issue like a fact, like Professor Krakoff pointed out, that supports their cause, and they kind of tacitly ignore the other facts in the record, and they come up with a decision. They resolve the dispute between those parties without forever deciding the issue in constitutional terms. Now, some of us are frustrated, well, they avoided, they ducked their job. Well, I'm not sure that so much they ducked their job as they decided that maybe the answer might not have been what people necessarily wanted, or might not have been able to understand how that could play out in the future. And I don't necessarily think it's a bad thing to sometimes avoid difficult constitutional questions if you can resolve a case otherwise. It's called the constitutional avoidance doctrine. I was guilty of it a few times myself in the Sunburst case, for example. And I don't think it's always such a bad thing. It allows these cases to bounce around, let people decide, different lower courts decide, and we're having a number of those type of discussions going on in the country right now. And we have a classic example is the gay marriage case. It's working its way through the federal courts at the district court level and the Court of Appeals level, and people want the Supreme Court to grab that and decide it forever. And I'm not sure it can ever be decided fully once and for all, and the process seems to be working. So we'll get there. Our next speaker now is changed topics slightly. Professor Marilyn Smith. Many of you know her. She's a professor at the University of Montana Law School, and she's also director for the Marjorie Hunter Brown Indian Law Clinic, where she supervises the work of third-year law students dealing with Indian issues. She teaches various Indian law courses throughout the law school year, as well as the Indian Law Summer Program put on by the law school. Besides her teaching duties, Professor Smith serves as the Chief Judge of the Southern Ute Indian Tribal Court, Appellate Judge of the Southwest Intertribal Court of Appeals, as well as legal counsel for the Confederated Salish and Kootenai Tribal Court. Professor Smith earned her bachelor's degree from Fort Lewis College and her law degree from the University of Montana. And Professor Smith focused her scholarship on child courts, the Indian Child Welfare Act, and tribal code development issues, tribal code being tribal law development. And she will talk about the concept of congressional plenary powers and how that impacts tribal federalism, focusing on the Major Crimes Act, and that's the act that gives the federal government the authority to enforce criminal law within the boundaries of Indian reservations, the Assimilative Crimes Act, Indian Civil Rights Act, Tribal Law and Order Act, and the Violence Against Women Act. And the federal judges in Montana routinely deal with these kind of issues and how they come up in our court. And we have a recent example, maybe Professor Smith can get onto this, looking at how tribal courts, these are domestic dependent nations, they have their own court system, and how that should be interact with our federal court system. And we have the Violence Against Women Act reauthorization contained a provision that turns a habitual domestic offender into a felon in federal court. So if the domestic abuse takes place within the boundaries of the tribal, of the reservation, and the defendant is an Indian person, and that fourth offense turns into a felony that's prosecuted in federal court. Well, Judge Waters and I both had recent issues where several of the predicate offenses involved uncounseled situations where the person in tribal court was not, there's no right to counsel under the Indian Civil Rights Act, and many tribal courts do not provide counsel in criminal cases. And in both cases, the defendant, my court and Judge Waters' court, had actually served jail time for the tribal court convictions. So now we're coming up on fourth offense domestic abuse situations, and they're being prosecuted in federal court, and the defendants in each case filed motions to dismiss for lack of jurisdiction because some of the predicate offenses failed to satisfy due process requirements regarding federal court. And we had both of us had involved hearings about the issue, and separately came to the conclusion that an uncounseled conviction in tribal court could not be used as a predicate offense to bring a felony charge against a defendant in federal court. Now, this is a very divisive issue. The Court of Appeals for the Ninth Circuit ruled this week in an appeal from a case that Judge Shandstrom had decided the other way, that under Ninth Circuit precedent, these kind of convictions could not be used as predicate offenses. And the Eighth Circuit and the Tenth Circuit have ruled the other way, that they could. And in each of those cases, in the Eighth Circuit and Tenth Circuit, the district court ruled that the predicate acts, that the uncounseled convictions could not be used as predicate offenses. And now, as a district court judge on the ground, right there in the trenches working, I tend to see the wisdom of those district courts in 8th Circuit and 10th Circuit and what they're doing, and it makes me have a few pangs of guilt looking out here at Judge Rice, for example, his capacity as a trial court judge and my former role as an appellate judge, and thinking that these appellate judges, they're too remote to understand what's going on in the real world out there. So those of us in the district courts have a better feel for it. We're isolated enough as federal judges, let alone being appellate judges. So anyway, these issues routinely come up in federal courts as we try to strike a balance between the federal government and the tribal governments enforcing criminal law. What should we deal with tribal courts, and what purpose do they play in the process? And there's a number of initiatives outstanding where tribal governments are going to be allowed to have jurisdiction over more serious crimes. I think there's up to 3 years is the latest proposal in place where the potential punishment runs up to 3 years. Those cases could be tried in federal court, or excuse me, tribal court, in front of tribal judges, tribal juries, and they make their own decisions about that, and they actually be punished and incarcerated in tribal-run jails if that's the situation. So, Professor Smith, look forward to your comments.
So I'd like to thank the law review for inviting me. Again, I'm going to make the caveat, I don't do constitutional law. So when I think of federalism, I think of federalism as a shared power issue and how you look at those shared powers in regards to tribal governments and how they fit into the scheme in regards to the federalism that you normally think between the state and the federal government. So my first reaction is, well, federalism doesn't kick in because tribes don't come under the Constitution. So why are we even discussing that? But I think you have to go deeper than that. So there are two provisions that sort of, I think, govern how we look at federalism when we're thinking of tribal governance issues. And the first one we've already had mentioned, and that's the Commerce Clause. So just so we're clear here, I want to read the actual language of that Commerce Clause so everybody's on the same page. And that is Article 1, Section 8, that gives Congress the power to regulate commerce with foreign nations and among the several states and with Indian tribes. So it's with Indian tribes is the language that we're using as one of the bases for saying that the federal government gets to have some say in what happens in Indian country. And then the other piece of the Constitution that I think kicks in that is often not thought about is the treaty-making clause, because that's how the relationships developed initially with the tribes and the federal government, was through the treaty-making clause. And that gave the president the power to enter into treaties with the tribe as long as 2/3 of the Senate agreed to that. And that's where we get all the treaties that we're entering into. So those are the two constitutional provisions that sort of set up a framework that then a concept of federalism comes out of. When they were entering into treaties, at least with the early treaties, There's nothing in those treaties that indicate that the tribes viewed themselves as being part of the federal government in any way, shape, or form. The closest you get, for example, the Treaty of Hopewell in 1786 with the Choctaw Nation says that the tribe acknowledges that they will basically be under the protection of the United States and not of any other sovereign. That's the only kind of language that indicates there is any kind of acknowledgement of a relationship with the federal government. So those are the framework that lays the groundwork for Justice Marshall. And Justice Marshall is who developed this concept of plenary power, that Congress therefore has plenary power over anything that happens in Indian country. So we don't have a large body of work here for developing that. So Justice Marshall has 3 cases. They're called the Marshall Trilogy. For those of you that do Indian law, you're very familiar with the Marshall Trilogy. So Worcester v. Georgia and Cherokee Nation v. Georgia are the primary ones. If you're interested in property law, you're going to look at Johnson v. McIntosh. But those are the 3 cases that make up the Marshall Trilogy. And under those cases, Marshall develops this theory that the treaties create a guardian-ward relationship. That's what he views those treaties as creating. And I'm going to tell you the guardian was not the tribe and the ward was not the United States in his view. And then as a result of that guardian-ward relationship, there then becomes a trust obligation. So it's that fiduciary duty that we think of when we have trust obligations. That doesn't necessarily play out in the same fiduciary duty that you may think of in trust obligations. And then the second piece that he looks at is the Commerce Clause. And when he looks at all 3 of those, he says those provisions and those concepts then create a concept where Congress has plenary power over Indian issues. So how does that play out? How that plays out is you now have a situation where you have a sovereign power who virtually has absolute control over another sovereign power. That's not a federalism concept. That isn't a shared power from his view. It is a view that the Congress has the right to do pretty much anything it sees fit when it comes to Indian affairs. Justice Morris has talked about some of the things that they've done, and one of the things that comes about fairly early in this, well, there's actually 2 things. One of them is an education policy that greatly impacts Indian country, and the other is the Major Crimes Act. And the Major Crimes Act is a piece of federal legislation that says the federal government can exercise authority in Indian country when there are crimes that fall under the major crimes, and they identify, initially I think it was 9 offenses, 7 or 9 offenses, and now I think we're up to 16, 17? 17 offenses now. So they keep expanding on that. So think about this, if Canada said to the United States, gosh, we don't like what you're doing, and so our Supreme Court has, or our government has decided that we get to step in when you have offenses that occur between your citizens, and we don't think you do what you should do, we get to step in and handle it. And that's essentially what the federal government did under the Major Crimes Act. These weren't crimes that involved non-Indians even. These involved 2 tribal members, is what this originates out of. That the tribe had handled the dispute and resolved it according to tribal customs and traditions, and the federal government didn't like the way the tribes did it. The Supreme Court was fine with it, but the federal government did not, and so they passed the Major Crimes Act. That's what leads to some of the scenarios that Bryan Morris is now having to hear as a federal judge here. So we have the Major Crimes Act. We have the Indian Civil Rights Act that's also passed by Congress. And the Indian Civil Rights Act was not something that tribes asked for. Again, it was the federal government that stepped in and said, we need to have something in place that gives rights similar to what's in the U.S. Constitution to anybody in Indian country. But what's one of the rights they don't include is the right to counsel. What's one of the other things they do is they limit the sentencing power of your tribes. So they don't limit the type of crimes they can hear, they limit their sentencing power. They still have the ability to try individuals for murder, but what kind of sentence can they impose under the Indian Civil Rights Act when it was originally passed? 1 year. That wasn't a tribal decision to do that. That was the federal government's decision. So that's that plenary power that plays into how matters work in Indian country. Along those same lines, in recent years, we've had the Tribal Law and Order Act. Now, what the Tribal Law and Order Act does is it increases a tribe's ability to sentence people for a longer period of time. It does not necessarily change the type of jurisdiction they have over the offenses. Those stay the same, but they can increase the amount of time to 3 years for an offense and up to 9 years if they stack offenses. But now this is where the federalism starts coming in. That power to increase sentencing is only going to be allowed if tribes adopt a model of resolving the disputes within their justice system that fairly closely mirrors what you see in your federal and state courts. So we're not allowing tribes to exercise that jurisdiction if they're going to handle matters in a way traditionally that they've done it, which is often restitution, rehabilitation, and trying to restore basically harmony within your communities. That's not what we're looking at here. We're looking at imposing a system of resolving disputes that mirrors what you see in your state and federal systems. And that's the only way that you're going to be allowed to recognize that. Additionally, we now have the Violence Against Women Act. And one of the things that the Violence Against Women Act does that I think is very interesting because of the language used in that act is it recognizes a tribe's inherent power to exercise jurisdiction over non-Indians committing the offense of domestic violence within Indian country. So I'm thinking inherent power means that they've had it all along. But what Congress has done is they say you can only exercise this inherent power if you do certain things. And that, again, is imposing a system that fairly closely mirrors what you see in your state and federal systems for governance. So you have that restriction. Now, what is interesting about the Violence Against Women Act is it also allows the federal courts to recognize those convictions from the tribal courts. And I've indicated that those convictions from tribal courts under the Indian Civil Rights Act, which is a piece of federal legislation, do not have to be counseled. And they frequently are, because tribes do not have the resources to provide public defenders for all of their citizens or all individuals within Indian country. So the issue becomes what kind of recognition should those uncounseled convictions be given in your federal courts when they come before your federal courts. I don't know whether you'll be happy to know, Justice Morris, but I agree with your decision. So my concern has always been with those uncounseled convictions is that the individuals do not know what the ramification of pleading guilty, and they often are pleading guilty to these in your tribal courts are going to be. So when I sat as a tribal judge, I often got the guilty, I guess, pleas. And the guilty, I guess, pleas, when you say, well, why do you think you're guilty? And they said, well, they wouldn't have charged me if I hadn't done something. Well, that may be true, although not always. And I think that when you started questioning them a little more to try and build that foundation as to have you committed this offense that you've been charged with, you would find that what they thought they did is not what they were being charged with. But in the tribal setting, I think you get a lot of guilty, I guess, pleas that then, without some kind of explanation, can potentially be used to enhance to a felony in the federal system. So I am concerned about those types of convictions being used to enhance to a felony in your federal system. Number one, if there isn't something in the lower court record that indicates that that possibility has been explained to them. But more importantly, I would want to know that the tribe wants that to happen. To me, that's the piece of sovereignty that gets missed in some of these legislation is nobody's asking the tribe, is that what you want? Do you want your convictions to be used to enhance these for sentencing purposes in the federal court? There's a parallel case to that came out of the Montana Supreme Court where they did the same kind of thing in DUIs, where the individual had some DUIs that he'd been found guilty or pled guilty to in a tribal setting, and then those were trying to be used to make it a felony in the state system when he came in for a DUI there. The tribe had never been contacted in regards to that, and in fact, if they had contacted the tribe would have said, we do not want those used. And as a result of that scenario, the tribe quit reporting its DUIs to the state because that's not what they wanted to happen. So if you're looking at federalism and how you do that shared power, part of it is that communication that has to happen. And that communication means that you need to see what the tribe wants to happen with its convictions rather than just what the federal government thinks should happen. And I think that's one of the pieces that is often missed when you're looking at sovereignty. And I don't know where I am on time. Am I done? I mean, I can go on, but I also, this is a good place to think. The other thing, but I guess I will go on just a little bit. I think one of the other pieces that you see where I think there's a federalism issue is the relationship is supposed to be between the federal government and the tribes. But what you've seen in recent legislation is the federal government delegating some of those responsibilities to states. And so tribes are having to negotiate with states for sort of economic development issues. Indian Gaming Regulatory Act is a perfect example where the tribes have to enter into compacts with the state. They did not enter into treaties with states. They entered into treaties with the United States. So you have a delegation of power there. Some of the water quantification issues that are in the news here locally are a reflection of that federal government delegating responsibilities over issues that may impact the tribes. Public Law 280 is a huge issue where the federal government just decided it would extend state jurisdiction into Indian country, into the tribal reservations in particular, without getting any kind of approval from the tribes. So these are all examples where the federal government has used that power, that plenary power that was developed under the Marshall Trilogy, and said we can impose regulations with an Indian country without having that kind of a discussion. So I leave you with the idea that Indian people are probably the most regulated individuals in the United States. There are 4 volumes of Title 25. That may be even more than the tax code, Martin, I'm not sure. There are 46 sections in Title 25, and Indian people have federal legislation that impacts them from birth to beyond death under those codes. So they are really there is a highly regulated system when you're dealing with Indian people and Indian issues in Indian country. And I think federalism has been skewed significantly when you're looking at tribal issues.
Thank you, Professor Smith. I think you raised some interesting topics. You think about Justice Thomas's concurrence in the adopted baby case. He's very clear. He says the Interstate Commerce Clause limits Congress's ability solely to regulating trade with Indian tribes. Now, taken to its logical conclusion, what happens to the Major Crimes Act? Because Congress is no longer regulating commerce with a tribe, they're regulating conduct of individual tribal members, which is something Justice Thomas says they cannot do. So calls into question the Major Crimes Act. And why is that important? Well, currently the federal government enforces criminal law in felony situations on Indian reservation. And there are 4 Indian reservations in my division in the Great Falls part of the district, including Fort Peck, Fort Belknap, and Rocky Boys, which are literally on the highway to the Bakken area from the West Coast. And besides transporting workers to the Bakken area, that same highway is transporting huge quantities of methamphetamine, firearms, other destructive devices that are wreaking havoc in the Indian country as well as in the Bakken. And who's going to enforce those laws? Those tribes currently don't have the resources, so the federal government has stepped in, and not without a price. The price is that Indian persons are charged in federal court. They alone are taken out of their community, brought to Great Falls, tried before a jury of their peers. In this case, their peers is the registered voters and licensed drivers in the Great Falls Division of the Court, which stretches from East Glacier to the North Dakota border. So typically, I have about 1 Indian person in a jury pool of about 45 people. So you can decide if that constitutes a jury of their peers. And then if they are convicted, they are sent off to federal prison anywhere in one of the 50, well, Montana does not have one, anywhere in the other 49 states, far from their home, to serve prison terms that, in general, far exceed the comparable term a non-Indian person would be committed to if they committed a similar crime outside somewhere in the state of Montana outside of Indian country. And I always chuckle when I think about how these laws get enforced. We have FBI agents sitting in Conrad, other places, who go out and investigate. And we have one agent now who spent the first 5 years of his career in front of a computer investigating the financial frauds perpetrated back in advance of the 2008 financial crisis. Well, he'd been recently transferred to Conrad, and now he's running around the Blackfeet Reservation investigating domestic violence situations, sexual assaults, other very serious crimes, but quite a different circumstance than he had in front of the computer in New York. So now we're going to stick with the theme of law enforcement and the role of the federal government in enforcing laws in Indian country. And we're going to have Danna Jackson as the speaker next. Danna occasionally has to appear in front of me.
That's right.
So I'm sure she'll be on her best behavior today. Danna received her law degree at the University of Montana School of Law.
Go Grizz.
She I don't dispute that sentiment, but I've got another big game in mind tomorrow taking place in South Bend. So Danna formerly worked for the National Indian Gaming Commission, where she served as advisor to the commission regarding all Indian gaming issues, and also serves as a visiting professor teaching Indian gaming, contemporary issues in Indian policy, and Indian education as part of the University of Montana Law School's Indian Summer Law Program. And Ms. Jackson will be discussing federalism that relates to tribal sovereignty and her role in convincing the tribes it's a good idea to have the federal government enforcing crimes. And you should know that the situation in Indian country with respect to criminal law is quite dire. The chances of an Indian woman being the victim of domestic abuse or sexual assault are about 3 or 4 times of what a non-Indian woman living outside of Indian country faces. And we really have almost epidemic levels in some portions of Indian country, and it's quite tragic. And this is one step being taken to try to remedy that problem. And besides, you know, I see the poor defendants who get shipped off for long periods of time, but behind each of those poor defendants are even poor victims who don't have a voice to speak on their behalf under the current regime, absent someone in Danna's position from the federal government who's showing up there to investigate these crimes and prosecute them. So, Danna.
Thank you. Thank you. Thank you very much. I am an assistant United States attorney, which means I'm a federal prosecutor. I'm assigned to the Indian Country Crime Unit. There are 6 of us in this state, and we are assigned to each of the jurisdictions that have federal jurisdiction. So Flathead is different, and it is a PL 280 jurisdiction, so the felonies on those cases are handled by the state, and it was something that they came to in the 60s. So that's different than the other circumstances. So I do prosecute violent crime, and you know, our bread and butter is sexual assault. I'm also the tribal liaison in the office, and in that capacity, I drive in circles. In fact, I was in Lame Deer all day yesterday, but my job is to try to work better relationships between the U.S. Attorney's Office and our tribal governments, and a government to government, and in a respectful way. This gets really complicated when your colleagues are prosecuting tribal leaders for white-collar crimes, as you can imagine. So I focus a lot of my energy into building capacities in the tribal courts and also in the just excessive and continual training of tribal law enforcement. Because as you can imagine, if you are an agent sitting in Conrad and there's a murder that happens in Browning, who's there first? Your tribal cops. And it will generally be a federal investigation and a case in federal court. So we need to make sure that those folks on the ground are quite aware of search issues, all of that stuff. So I spend a lot of time and energy in Indian country doing a lot of training. I don't need to explain criminal jurisdiction in 100 words or less, because it's been done for you. But since 2010, there has been 2 significant laws that expand or restore the jurisdiction that had been taken from the tribes through acts of Congress and through the Supreme Court. And one, of course, is the enhanced sentencing provision of the Tribal Law and Order Act. This is a 222-page act that basically tells feds how to do better by having better relationships interagency as well as with tribes. But this also says, yes, if you, in fact, I have them. Hold on. I'm a PowerPoint person. Can you see it? This has been called enhanced sentencing. So these are the provisions that tribes must do and have before a tribe can have the authority to sentence up to 3 years, stacking up to 9. They have to provide licensed legal counsel to the defendant. They have to ensure that the presiding legal tribal judge is licensed and law trained. They have to publish their tribal criminal laws, rules of evidence, and court procedures. They have to maintain an audio and video record of the criminal trial. They, of course, would have to modify their code to reflect this. And if they don't want to do this, or case is not subject to this, it's status quo. Of course, we've also heard that in 2013, Congress passed another law, and in this instance, it's called the limited Oliphant fix. Before, non-Indians beating the hell out of a person on the reservation in a misdemeanor context was not a matter for tribal court. Tribal court did not have jurisdiction over a non-Indian. But now they say, if you meet similar requirements, you can bring those misdemeanor cases in tribal court now. And so Oliphant was the case that said tribal court did not have jurisdiction over non-Indians in the context of criminal law, and that can change. There are three pilot projects right now that are trying this out. Part of it is getting a fairer jury pool in your tribal court systems. Fort Peck is on the cusp of being another pilot project. And we're very proud of that. We're very excited about the fact that they have stepped up and want to show how large land-based tribes in remote areas can do this and do it right. And they are, making important steps to make this happen. In that regard, Montana is on the cutting edge again of Indian law. If it doesn't become a pilot project in 2015 of March, they can do it anyway. So 2015 of March is when tribes can assert themselves in this context, should they meet the requirements. So I have a good message of, I think, unprecedented cooperation between the tribes and federal governments. And I say this because the 6 attorneys that are required to do Indian country have major liaison roles. We go, and I have another slide. I'm really awkward. We are required to go to the reservations. We're not going to prosecute our way out of this problem, right? So we go to the reservations, and I'm just going to talk about 3 different things that are happening, because there's a whole lot of things happening where there is, like I said, unprecedented discussions about what's the best thing to do with this case that has arisen on the reservation. The one that I really want to point out here is MDT teams, multidisciplinary teams. These are a group of multidisciplinary people who staff every case of sexual and physical violence involving children. And we have pediatricians, we have federal and tribal law enforcement, federal and tribal prosecutors, and we have school counselors. Every case is discussed with a mind towards prosecution. We can't prosecute every case, but it is staffed. And that's very exciting. And in this instance, a lot of times that I find very helpful is we'll say, wow, okay, well, I don't know that I could prove that he sexually abused this child. And someone from the reservation who's a part of this confidential discussion will say, yeah, but you know what? He also sexually abused her cousin. And so then you may have a case. So some of the real benefit to this discussion is identifying, frankly, the serial child abuse, perpetrators. The other one I want to point out is the sex assault response teams. This is relatively new. Mike Cotter, the boss of me, as well as he was the Associate Attorney General at the time, Tony West, came out to Montana and they announced that we're going to have a sex assault response team on every reservation that has federal jurisdiction. And so that is similar to an MDT in a confidential setting. We staff and discuss every instance of known sex assault. This is involving grown-ups. So instead of like the pediatricians, right, we'll have the SANE nurse. And it's a very different type of sex abuse. It's usually acute, usually in the middle of the night. It usually involves a sex assault exam, et cetera. But we're staffing those cases too. And that is great, and it's wonderful, and there's an eye towards healing, which is a wonderful thing because you don't get a lot of healing in our federal system. I want to say one more thing about levels of cooperation that are happening, and this includes the state. We have the first of its kind in the nation called the Native American Intimate Partner Fatality Review Team. And what we do is we review certain cases starting from birth to death to see if there were opportunities for intervention or lessons that can be learned so that we can prevent intimate partner homicides in the future. It's super cool. It is incredibly difficult to slog through. We interview victims that are alive, and it's an incredible process. More to come on this, but it's a very, I think, important piece of work because intimate partner homicides in Indian country are different. And one of the ways it's different is in Indian country, 6 of 10 of the perpetrators of intimate partner homicide in Montana are women. And my theory is it's because women, when they fight back, have to have an equalizer. And I think that you're going to find in our review that probably these people were victims of domestic violence themselves. So more to come on that. I think it'll be really interesting findings. And we're very proud of the cooperation that's happening amongst a lot of very interested people. So the most important thing that our office is doing is twice a week, we have conference calls with the tribal prosecutors. And given the fact that they may have more jurisdiction than they have before, we staff every single case that arises that might be a violent crime issue that may look federal. And we staff it at the beginning because it's the best thing to do for resource purposes, but it's just the right thing to do to get tribal buy-in. Because what happens when you don't have tribal buy-in? Well, it's potentially disastrous. And in that context, we make joint decisions as to whether a case is better for federal court or for tribal court, and the system is working. I have a slide. And this kind of takes on Marilyn's, I guess, viewpoint to a certain degree. Restoring jurisdiction, making sure tribes can assert jurisdiction is good, right? Why would that be bad? And I think Marilyn made a case for that, right? So you're requiring tribes to look just like the federal and state courts? Well, we happen to think that more local control, frankly, defederalizing criminal jurisdiction in Indian country is a good thing. We also think that tribes have a hella lot more flexibility in sentencing, don't they, Judge Morris, than the federal system does. So maybe if they are the ones to assert jurisdiction in certain types of federal cases, they can fashion sentences that might be more restorative in nature. And I will tell you, the conversations we have, nope. Whoops, I screwed that up. The conversations we have in the context of who's best to proceed on this case, and tribal courts can do something, does operate better and quicker sometimes, for sure, comes down to resources, right? Who really can deliver in this instance? And we have a tribe who does not have adult probation services. Can we really suggest that they're the sovereign who should move forward and proceed on a serious assault case where the underlying issue is substance abuse? It's just not right. So until we have tribes are enabled to have full capacity and ability throughout their government to address these issues, sometimes the feds will continue to be the only game in town. Now, this is a cool picture, which is part of why I used it as my concluding slide. But it also is to remind me about our SAUSA program. SAUSAs are Special Assistant U.S. Attorneys. And this administration is very keen on us promoting and getting Special Assistant U.S. Attorneys that are licensed in the tribal system as well as the federal system, so that those folks can bring cases in the most appropriate court. We have one right now in Fort Belknap, and clearly she's very, very competent. Fort Peck is looking for one right now. These are for grant funds. So even though you can be designated a special U.S. attorney without federal money attached to it, Fort Peck is looking for one just for domestic violence purposes and sex assaults specifically, to address the Bakken issues and the uptick of crime that are seeing there. So very cool. This is a message for the law students out there. Consider being a tribal prosecutor. Talk to us, and perhaps you should become a special assistant U.S. attorney and have the experiences in both courts. And I don't know, Judge Morris, in the first 6 weeks, did you have 10 trials? We try cases. 8? We try cases. And in terms of extraordinary experience, I would just suggest that you look really hard at tribal systems as a great place to get your feet wet, especially if you can have a relationship with us. So anyway, that's all. Thank you, Colin, for your patience. Thank you, Samir, for saying, yes, I realize you're not non-academic on the panel, but you have some you have important contributions to this. And so thank you very much for having me. And once again, go Grizz.
I hope you're not lumping me with the academics. Someone once asked me, I was interviewing a law clerk candidate, and he asked me, well, who did I write my opinions for? I thought about it for a minute. I said, well, law professors write an awful lot. I'm not sure anyone has to read that, but at least the parties in my case have to read the opinion. So I think I write for the parties so they can find out the outcome. We're going to shift gears slightly now and get back to my Ivan Doig Forest Ranger character. Michelle Bryan's going to talk about land use and the issues that it creates with respect to federalism. Michelle is a law professor at the University of Montana School of Law, along with co-director of the Land Use and Natural Resources Clinic. She graduated with high honors from the University of Montana Law School. She was the editor of the Law Review. She worked before law school as a specialist with the Water Resources Center in Bozeman. She's well versed in resource issues. She's been a terrific teacher. She received the Garlington Lawn Robinson Faculty Teaching Award, as well as the Marjorie Hunter Brown Faculty Merit Award for her classroom teaching and research skills. And Professor Bryan is working on an article on the role of various levels of government and land use planning. It's titled, quote, "A Constant and Difficult Task, Making Local Land Use Decisions in States with a Constitutional Right to a Healthful Environment." I believe Montana is one of those states with such a provision. So, Professor Bryan, would you please lead us down the path of federalism with respect to land use?
We're charging those left and right now. I should have brought that up. I can. The other one that we haven't charged is substantial bodily injury, which is a 5-year maximum. Only in the context of domestic.
Well, like Professor Krakoff, I have 2 potential titles to an article I've been working on with students Graham Coppice, Caitlin Hepburn, and Ross Keogh. So I have to thank them very deeply for all the work they've been doing. One title is Learning Both Directions, Building Bridges Between Federal and Local Land Use Planning. The other title is Cause for Rebellion, ? Examining how federal land management agencies and local governments collaborate on land use planning. And before the latest hubbub where states began asking to transfer lands, federal lands back to state control, I got interested in the topic of local-federal collaboration in land use planning, because in our land use clinic, some of our clients were puzzled over what role they could play when different federal agencies began planning how they were going to manage lands that are interspersed with our private lands, which local governments regulate. Since we started that work, it's become a very hot topic. We didn't realize it at the time. So on this first slide, there's a picture of Senator Fielder from the state of Montana and Representative Ken Ivory's state of Utah, which this last spring had held a summit on the transfer of federal lands to state ownership. And 9 different states sent representatives to this summit. It's part of the Republican National Committee platform that federal lands go into state control. It was just put into the Montana Republican platform. It's also the platform in other states. Well, Utah has passed a law demanding transfer of control of federal lands within that state to state government. So what we tried to do in the clinic, I and the students, is to peel back the conversation and ask, what are some of the things at the root of this problem? Is there real merit to this rebellion, this second sagebrush rebellion that we're seeing? And so what we wanted to do is look at how is the federal government going about its task of creating plans for federal lands, whether it's parklands, wildlife refuge lands, BLM grazing lands, forest service lands, wilderness areas. And so the students spent hours interviewing federal planners and county officials and county planners that were involved in joint endeavors in theory and sometimes in practice where plans were proposed and then adopted. I thought it would be best to illustrate the complexity of this collaborative planning with a case study. So I picked the CMR Wildlife Refuge, which is a refuge that follows a river system. And so you can see in the green area that the refuge boundaries actually cross through 6 different counties in Montana. They're also very near 2 reservations. And it's harder to see, but off to the right, underneath of Fort, we've got Fort Peck in the upper right-hand corner, Fort Belknap, upper left. You can see Turtle Mountain tribal land as well in a few places. And there's also a national monument on the cross-hatched area in the upper left. So this is just very typical of the different types of land ownerships that can exist in the different jurisdictions over one area that needs to be planned. So the federal government is charged with creating a plan for an area like this refuge or a park. At the same time, local governments have been delegated federalism powers to regulate land uses within their jurisdictions. And it's very clear in just reviewing state enabling laws that enable local government planning that there's not a tradition of local governments being told to think about federal land issues when they plan. Most enabling acts don't mention it at all. A couple of them, just in recent years, Wyoming and Montana said, we enable you to cooperate with the federal government when it plans, but there's no heritage at the local government level of even thinking about how do the federal lands fit into our local vision. In fact, I think the predominant message over time has been, don't even think about it because you have no jurisdiction, you can't regulate it, you're preempted. But the end result then is that when federal agencies start planning, local governments aren't hitting the ground running with their own input and ideas that have been developed in advance. So that's been one difficulty that we run into. The difficulty on the federal side is that the language of planning is so different than what local communities think of when they're planning. And a local government might collaborate with U.S. Fish and Wildlife Service on a refuge plan, and then the BLM on a sage-grouse plan, and be treated very differently in those 2 planning processes. And it becomes confusing. What is the protocol for dealing with the federal government? Each agency, BLM, Forest Service, U.S. Fish and Wildlife, National Park Service, has a separate set of planning rules that it must follow, along with manuals on planning and handbooks and regulations. So local governments can really get lost at sea in trying to figure out how to relate to these different planning processes. And if you look, for example, at the plan that was produced for the CMR, it talks a lot about population trends. And you have to take a minute to think, oh, they're talking about like the bighorn sheep. But if you look at population trends for Phillips County, they're talking about people. How do we get more people here? So the language is just quite different. This is, you won't be able to read the fine print, but this is just Phillips County, one of the 6 counties that is part of the affected area, and all the colored area is public land, right? So in the West, almost half of our lands are public, and in this one county, it looms very large. Here are just some of the kinds of resources in the area. This is the refuge, some of the critical wildlife that's important in the area. Some of the other neighboring land uses, lots of ranching. There's mining and extraction. There are tribes, as I pointed out. There's American Prairie Reserve. It's a private nonprofit foundation buying land next to the refuge with the goal of bringing back bison and prairie habitat. So you've got all these different interests involved. It's very difficult to figure out how to plug everyone in. And in this particular area, the local government had no plan in place to sort of state what was important to their community. So they hurried up and tried to rush one through. The overarching law that invites states, tribes, and local governments to participate in federal planning is NEPA. It provides the opportunity to be a cooperating agency. But it's very discretionary, and it's up to a particular agency to decide whether to include these partners. And so what we see is a lot of discretionary practices among the agencies and the particular individuals tasked by that particular refuge or other area with planning. Some of them are very interested in local participation. Some of them are not. Some of them want to check off the box and say we invited them to the meeting. Some of them hold meetings year-round, even when they're not planning. So the practices vary greatly. And our report really recommends that the agencies work hard on making some uniformity in the way they include local communities. And that they also really think about how to share resources so that when the federal government and the local government both need to plan, they could pool together and do shared studies and technical reports, since neither of them have a lot of money to do good planning at the moment. So we make lots of different recommendations in our report. It's coming out at the George Washington University Environmental Law Journal. So you can look there for more detail. Let me see what other slides. This is one of the most compelling quotes, I thought, that we got from our interview, which tells me that more needs to be done to quash this sagebrush rebellion, stage 2. And it was from a commissioner. In this particular project, only 2 commissioners got to participate, even though there were 6 counties. It went over several years, and she said in the end, I just felt like nothing we had to say was even considered. Under NEPA, certain things are considered under the law insignificant, right? And if they're insignificant, they don't have to be addressed in an environmental assessment. So they were told that their concerns over road access and economy and wolves were insignificant legally. But these are local people, and they don't understand that that's a legal jargon. They felt like they were told their concerns didn't matter. So there's just a language barrier, I think, between the federal planning laws and the way local people look at planning. So we want to get to a place where at the end of a long process, the local government isn't feeling like nothing they had to say was worthwhile. On the other hand, they have things in their plan that they think they want to make the federal government do on the refuge, like carry out everything to benefit our county and increase privately controlled land. So on the local government level, we saw a lot of political posturing and demanding that shows they aren't being entirely collaborative either. So we found room for improvement on both sides. And I'll stop there.
Thank you, Michelle. In the few minutes we have left, I would like to give the audience a chance to ask questions of our panelists. So, we have microphones here. Anyone have any questions? Right here in front.
I don't really need a microphone. I'm pretty loud.
Okay.
I just had a general question.
Would you identify yourself?
Rick Hills. I teach at NYU Law School.
Okay.
And I just have a general question about who is the interest groups in D.C. lobbying for more control of and more limitations on tribal jurisdiction? Is it the National Conference of State Legislators? Is it the National Association of Counties? What's the interest group that cares about this? I understand who's lobbying for more tribal autonomy and maybe building up tribal capacity. Who is lobbying on the other side, pushing the federal government to say, look, you can't trust those guys. They're hayseeds. They don't have the capacity. We need to have more federal intervention here.
All right. Danna, you want to take that first?
Sure. National Congress of American Indians is the largest entity that usually works on the tribe's behalf. But in terms of, and I was on the Hill when this started, the Tribal Law and Order Act and the VAWA 2013, the pushback was coming from defense lawyers themselves, who really, really care, and they, should, that these folks be represented in the tribal court, because the Indian Civil Rights Act said not, that's not the case. So that is generally who was giving the pushback and creating the requirements for tribal courts. Is that your understanding, Marilyn?
Well, I think the National Governors Association has also pushed back, not so much on that, but I do know when Slade Gordon was making efforts that he was using them.
What about national civil rights groups like ACLU?
Yeah, I can't speak for them. I know here in Montana, the ACLU is very supportive of tribes. So I think that may vary state by state. Nationally, I don't think they have a policy, although they've done quite a bit on voter rights issues in Indian country on a national level.
And I did not see ACLU in D.C. At the table necessarily on these issues. I will tell you one of the most effective entities in trying to get these reforms in place were the advocates, the tribal advocates on the ground who said, enough already. We really need to get systems in place to be more responsive to the dire concerns that the judge talked about.
Keep in mind that not all persons living within the boundaries of Indian reservations are tribal members, so that complicates the situation as well. Next question, please. Hold on. Your name, please?
Art McAmber. I'm a property lawyer in North Utah, or North Idaho. Thank you. I'm looking forward to a 3-hour drive home.
You're in western Montana now.
Yeah. I'm just confused today. For Professor Bryan, I have investigated the police power in Idaho, and it is what is used there to regulate land use by the state and local entities. And I'm wondering, from a U.S. constitutional standpoint, what is the authority in the U.S. Constitution to regulate these federal lands? I'm looking at the Property Clause, Article 1, Section 817. I'm not seeing a purchase from a state or a cession, so I'm confused. And hopefully you can enlighten me. And what state is this? No, just kidding.
Well, I think the parties on both sides of the debate about this cite to different portions of the Constitution and different land enactment acts. But in general, I think it is the Property Clause that's cited, as well as the Enclave Clause on occasion. So I think those are the two main sources that are cited. Professor Williams teaches public lands. She should jump up and chime in. She's in the back. Stand up. What are the other?
I actually was thinking we covered this in Introduction to Environmental Law and some in Public Land Law, and that some of our students are as well-versed in this. Do any of the students want to show off how much they've learned? No, I'm very serious about this.
This is the professor's version of further percolation.
Well, no, I think it's exciting. I think they have put a lot of thought into this. So are there any students who want to pipe in? No, I've put you on the spot. Well, I can promise you that they have been thoughtful on this, but I mean, certainly the property clause is the underpinning. But we talk about the enclave clause, we talk about the commerce clause, we talk about the treaty clause. We try to cover all different foundations for federal ownership. So,
Okay.
thank you,
Time for
Professor Bryan.
One more question. Yes. You will not get hired if you ask a question. Go ahead, please.
I think this is for
Identify
professors.
yourself.
What's that?
Identify yourself for
Oh,
those.
I'm John Wolf. I'm a student at Montana School of Law. I think the question is probably for Professor Smith and Professor Krakoff. If tribes are sovereign nations, then why shouldn't uncounseled tribal court convictions be used for prosecution underneath some of these persistent offender statutes? Like, would the same be true if a U.S. citizen was prosecuted in Canada, supposing that there was no right to counsel in Canada? Could that come in a court?
Or misdemeanor court, JP court in Montana.
Yeah.
So I guess I would say, you're going to have to look under comedy principles, and there's always that due process piece that comes under comedy. My concern is, I have no problem, and this is where I agree with Justice Morris in his decision, I have no problem with them using those convictions from tribes where I can tell from the record that the individual did understand the consequences when they entered a guilty plea. Particularly, it's the uncounseled guilty pleas that I'm concerned about, not the convictions, the uncounseled guilty pleas, which is 95% of what happens in Indian country. So if they understood those consequences, but you may not be able to tell that from the lower court record, and I don't know that the tribal court records are being given to the district courts. I don't think they are, so they can make that determination. So I think it's that I want them to do it under principles of comedy, which is really what I felt Justice Morris did in his decision, is look at that and say, I don't feel comfortable doing that because I can't tell. If they've got it, I have no problem based on that sovereignty concept and looking at how you recognize foreign judgments under comedy.
Let me just pipe in. This is a unique situation because of the tribes, but the statute says previous convictions in state, tribe, or federal court, and it makes no mention of uncounseled convictions. But there's no other situation in the federal courts where a previous uncounseled conviction can serve as a predicate act. Now, this is a tribal court. What if Congress says foreign convictions? We had a problem with a neighboring state. Would we really allow what's the most awful, a domestic abuse conviction in North Korea to be used as a predicate act if the person immigrated to the United States later? I mean, there are certain fundamental principles in our federal courts, and one of them is a right to counsel, and uncounseled convictions on their face are suspect. And particularly, we have an uncounseled guilty plea, which I think is more than 95%. I would say 99% of the cases in Indian country. So I don't see it as a disrespect in any way of what happens in tribal court. I think the tribal courts are authorized to do what they do, and they have sometimes their intent is different than our courts. They're not necessarily to get to a firm resolution of guilt or innocence and punishment, but they pursue other ends as well, and that's perfectly appropriate. That's not the question. The question is, can we use, if I'm going in to enter a guilty plea knowing, well, we're going to have a sit down with the victim and the assailant, work this out, I might make some reparations, sure, I'll plead guilty. I may have done it. But if I knew the consequences were something different, would that same person go ahead and enter a guilty plea? And I think that raises concerns for me about why we should twist federal court jurisdiction, which is very clear. In no other circumstance can an uncounseled conviction be used as a predicate act because it comes from tribal court. And that's no disrespect to tribal courts. They serve a different purpose, in my view, in some circumstances. And when you have that, when you have a situation of uncounseled conviction, I don't think it warrants use in federal court.
Judge, can I add a footnote to that?
Very brief. We're
Very
past
brief
12
is,
o'clock.
you should look at the Lakota First case that came out of the Ninth Circuit as well, where these are Gun Control Act cases where they're using uncounseled decisions in that context. Different language, statutory language, but it's interesting to compare and contrast, and that's all I have to
And on the
say.
final word, remember, the
He
conviction.
always gets the final
The
word.
conviction may come from tribal court, but they are American citizens. And as American citizens, they're entitled to be treated the same way in federal court as any other American citizen. And that means you cannot have uncounseled convictions used as predicate acts. All right, with that, we'll wrap up and thank my panel members for their thoughts. I'll see you after lunch.